May it please the Court, my name is Harold Lichten, and I represent the plaintiff, Robert Summers, who appeared in the lower court proceedings pro se. Your Honors, at a time when the legislature and the executive branch of the Commonwealth have sought to significantly strengthen enforcement of the near epidemic levels of violations of our independent contractor statute, one of the toughest in the nation, and other wage laws, the decision of the Court here, if left to stand, would eviscerate those protections, indeed gut those protections, and would allow for every defendant in a case in which they've been sued for violation of independent contractor violation, overtime, or other wage provisions, which are enforceable under Chapter 149, Section 150, a new and heretofore never heard of defense. And that defense would be that even though we violated the independent contractor statute or the overtime statute or the tip statute, if we had known about our violation or if we had not done so, then we would have paid the employee less than we actually paid them, and therefore we're entitled to a theoretical, abstract credit.
May I ask you, just to make sure I understand, one thing the judge said was that Mr. Summers was paid $7,059.76 more for the time he worked as an independent contractor. Summers does not contest these figures. Is that so?
He did not contest the amount that he was paid, which was, I think, for 6 months' work, about $45,000, a very intense
Well,
work.
let me back up. The judge said that the defendants contest the damages alleged by Summers, arguing that he was, in fact, paid more as an independent contractor than he would have been as an employee. And then the judge says, in fact, he was paid $7,059 more for the time he worked as an independent contractor. Summers does not contest these figures. And I just want to know if that's so.
It's not that the figures were inaccurate. It's that the methodology employed by the judge is never before heard of and is totally not supported by any case law that I'm aware of. That is, what the judge was saying was, I'm going to compare your salary, Mr. Summers, with other salaries for permanent employees there.
And that was perfectly appropriate. And the facts of this case just jump off the page. I mean, this person was in the business of independently contracting out his professional services.
That's not true.
So no, then maybe I've misunderstood the record. I thought he entered many contracts over the last 10 years with the predecessor to this company and this company to basically provide professional services under a contract.
The independent contractor statute here was clearly violated
No.
on all of those occasions.
Separate question. Separate question. He was in the business, whether or not the statute, he was an independent contractor for unemployment tax purposes and everything else. This was the business in which he was in.
He was a quality assurance engineer.
Right.
Who
Professional.
worked for companies.
On contract. Contract lawyers.
They may have offered him contracts because a lot of these companies were in an epidemic proportion violating the law, but he was an employee. He didn't have his own business. He didn't have his own cards. He didn't have an independently established trade or business. None of the criteria under Section
I'm not arguing with you as to whether or not under the law he was an independent contractor. He doesn't get the job as a full-time job as a quality assurance engineer.
Correct.
But they say, but we have a need, short-term need. We'll hire you under an independent contract. And he's done this before. That's what a lot of people, professional people do. He's done this before, sure. Well, what's built into an independent contract? Overhead. He gets overhead. Why? That's why he gets $65 an hour as opposed to what he would get if he had the same job as an employee of the company. He gets overhead. That's part of the deal. Now, you may say, well, he's not an independent contractor under the law, but that doesn't mean his wage was $65 an hour.
That was what his wage was. There is no right under the law for the employer, after having been found to violate the law, to go back and do this crediting analysis and say, well, if we didn't violate the law, we would have paid him less. If you open that door, then everyone from a janitor on up is subject to that analysis.
Your real point is this is not a private transaction. We have a statute here that imposes an obligation that says very, very, very few people can be independent contractors, and because there is a public policy here that these people are supposed to be called employees. You can call it whatever you will vis-a-vis this individual, but the law requires it to be treated that what he was paid for purposes of remediation has to be the salary. And then you figure out overtime and the rest of it from there.
That's correct. And then the proper analysis in this case, I submit to you, is exactly the analysis used by Justice Murtaugh in the Amero versus Townsend Oil case, which was recently decided, and which I've submitted to this court, that what the court should have said was there was a clear violation of the independent contractor statute. Indeed, below, the employer didn't even attempt to argue that they had not violated the statute, that there was a clear violation of the
This
overtime.
This is in Judge Murtaugh's case, not this one.
No. I'm saying this court should follow what Judge Murtaugh did. And what Judge Murtaugh did in that case was to find that once you find that there was a violation of the independent contractor statute, the case should then be remanded for a hearing before the trier of fact, a jury, on what the damages that flow from that. It doesn't allow the court, as a matter of liability, not of remedy, to decide on summary judgment that even though there's been a blatant violation of the Massachusetts wage laws, including the independent contractor statute here in this case, and the overtime statute here in this case, two issues which were not even really contested by the employer below, they simply made this crediting analysis, that the matter goes back for a hearing on remedy, and you determine then what the damages are.
And here, what the judge did was say, I think implicit in his decision is that there was a violation of the statute. Nevertheless, in order to recover, the plaintiff must have suffered damages.
That's correct.
And then
That's what he said. But that changes the law as we've known it in Massachusetts. It turns it on top of its head. Normally, you find on summary judgment, if the plaintiff moves for summary judgment, that there has been a violation, and you grant, as Judge Murtaugh did in the Amero case, you grant summary judgment to the plaintiff as to liability, and you remand to a hearing for damages. The judge here tried to make damages part of the liability phase.
I have a question, a procedural question. The defendant states that you didn't raise a claim based on the BISPAM hiring before the MCAD or in the Superior Court. So have you waived that?
That's, you mean on the discrimination?
Yeah.
Yes, the court went on to hold in that case that because of the lenient pleading standards for pro se plaintiffs, and my client was pro se in the lower court, that he went on to find that that claim was known about by the employer and therefore allowed it to proceed because it was timely and within the parameters of the general allegations.
But there was never an opportunity for the MCAD to investigate and have it settled there, et cetera, et cetera.
I agree with that, Your Honor. I still think the court was correct, at least on that point, that it was still within the rubric of the claim, and therefore properly he went on to just look at the merits of it.
With respect to the independent contractor law, I mean, it's one thing to say you don't get summary judgment on what the damages are, but that begs the question as to what the damages should be. And
yes.
I take it your point on the damages is, even if you did it before a jury, it's still would you would say you still would use whatever your client was paid and as the base, and then calculate from there with respect to any overtime.
That's correct. We have cited to you numerous cases from the decided under the FLSA, and I cannot find one case, and I don't believe there is a case, where an employer has been allowed after the fact to say the wage rate should be some other wage rate. In fact, in Mullally, I believe you outlawed this. Because of the fortuities of the case, there should be some other wage rate from which you calculate overtime. In addition to that, and I think this is very important, if he had been an employee, he would have been entitled to 401k contribution, health insurance contribution, vacation, holiday pay. Again, I believe those are all claims that 150, the enforcement mechanism for 148B allows. It says you may bring an action for damages and or lost benefits.
I thought those had been calculated.
They have been calculated
Based on what a quality assurance engineer, I think the higher paid quality assurance engineer was in fact making. right? And you say, oh, no, you got to do it on this artificially increased number, which of course includes overhead, which he is, because he is, whether legally or not, he is an independent contractor.
I'm saying that at worst, that was a question for the jury on remedy. The question would be, had he not been misclassified wrongfully and he was an employee, would he have gotten holiday pay? Would he have gotten vacation? And I don't think there's any case that I'm aware of that then allows some crediting analysis. I instruct you, jury, on remedy, that you're to consider what other people were paid who were not wrongfully misclassified, who had permanent employment, and you can apply a credit. I'm aware of no case that permits that. And if you permitted it, and this is the important point, then every time an employer is found to have violated the overtime statute, the tip statute, the wage statute, again, from janitor to senior official, then the employer is going to have a new defense. And that defense is, oh, well, maybe I violated the law, but, you know, if I had known I was violating the law, or if it had been brought to our attention, I would have not paid that person $10 an hour. I would have paid the person $7.75 an hour, or I would have paid the person.
Mr. Licton, we get the point. I'm sorry, but I want the Attorney General at least to have a few seconds, and you get your full 7. That's okay. Good morning, Ms. Szabo.
Good morning. Carla Szabo with the Office of the Attorney General in the Fair Labor Division. The statutes that are at issue in this case involve the Wage Payment Act, the Independent Contractor Misclassification Statute, the Overtime Statute. All of these statutes, they're referenced collectively in Section 150 of Chapter 149 and also in 27C, which gives the Attorney General our enforcement authority. All of these statutes that we're talking about, they're all strict liability offenses. And that strict liability, that applies to actions, whether they're enforcement actions brought by the Attorney General or private rights of action like here. The legislature decided to make these strict liability offenses. And I would suggest that that means that an employer's subjective belief as to whether or not they paid properly or classified properly is irrelevant under the law.
Well, so, I mean, strict liability means one thing in terms of liability, but would you say, but you're applying that also to the damages. That is, if you violate it, then whatever you paid, you're stuck with, and that becomes the base that then you measure from. Is that
That's
right?
exactly right. And this issue in the context of overtime payments has been litigated. For example, if an employer misclassified an individual as exempt under the state overtime law and purposely paid someone a higher rate than, say, a coworker, they can't go back in time after that violation is discovered and say, oh, had I known I was subject to this overtime law for this individual, I never would have paid them this rate.
Okay, let's take this example. You have someone who purports to be an independent contractor providing professional services, enters a contract with the company to be a quality assurance engineer for 3 months to work on a project, and agrees that they will get $65 an hour, which is intended to include all of the overhead that that independent contractor might have, including vacation, including Social Security taxes, unemployment, all of the things that the employer would otherwise be paying. So it's quite clear, and many of these contracts are, that all of that is part of the compensation one gets through an independent contract, rather an employment arrangement. You would say that's quite irrelevant. 65 is 65, regardless of what the parties intended.
No, I wouldn't say that. I would say if it was truly an independent contractor scenario, that would be what the parties bargained for.
No. The parties think they're truly independent contractor scenario. The law says, no. For a whole bunch of public policy purposes, you're an employee and you have certain protections. But when you come to damages, you're saying that's completely irrelevant?
I'm saying the employer's subjective belief is irrelevant. An employer may often, I would suggest you could even draw an opposite inference, that an employer purposely pays someone in cash compensation and cash wages a little bit more than they might pay someone they treat as an employee on the assumption that perhaps they're going to get away with something, that they're not going to get caught, that there's not going to be a violation detected.
So the employee has been paid more. So the employee has been paid more.
Perhaps they get a slightly higher cash amount, but maybe they're not getting any vacation. They're not getting paid holidays. They're not getting 401k. They're not being protected by workers' compensation coverage or unemployment. You know, the facts in this case, Mr. Sommers is not a particularly egregious example, but it's the rule of law the Attorney General is interested in. This person only worked there for 5 months, and it's a very limited exposure period. What if you changed the facts and this person didn't have health insurance and they incurred tremendous medical expenses
isn't
from
that
surgery?
Exactly what's happened here is the judge has taken a very close look at the facts. These are the facts. You were not hired as a quality assurance engineer full-time, but we had some need, so we hired you on a contract basis, which, oh, by the way, you've been doing for some time, paid you substantially more than you would have been paid as a quality assurance engineer, precisely to cover the overhead, in other words, all of the things that you would otherwise have been provided by us. Isn't that precisely what the judge is here? And why is that the wrong thing to do?
Actually, the judge in this case specifically found a violation of the independent contractor statute in 148B. He specifically found that there was a misclassification. An employer can't go back in time after a violation has been discovered and try to recreate a new wage payment.
Nobody's
a new wage
recreating
rate.
anything. I'm saying, I understand there's been a violation found. I'm talking about damages.
Ms. Sauber, would you agree with Mr. Licton, as I take it his position was that it can't be a rule of law, which is essentially what summary judgment is, but if this goes to the fact finder, and if the fact finder is a judge or jury, then the kinds of questions that Justice Cordy is posing can be introduced in evidence, and the jury can consider them or not?
Absolutely. It's a question of fact what the amount of damages were. What the Attorney General's office is saying is that this plaintiff was never given the opportunity to prove his damages. Maybe his damages are nominal. He's still entitled to a recovery under the Wage Payment Act, under Section 150, and under the misclassification statute.
So if, for example, there's been a violation of the statute, and I don't know if these are the facts in this case, and it is established by the employer that in reaching an hourly rate, the putative independent contractor said, look, you're not putting me on your payroll, but I have, a little mutual fund, and you would be paying me $7 an hour, and so you would be giving me an additional $2 for this and $1 what Justice Cordy provides as overhead. If that were established, would that be evidence that the jury or the other fact finder could take into account?
I certainly think it's something a fact finder should consider. All the facts and circumstances, the method of payment. There's no evidence in this record here that $65 an hour was anything other than $65 an hour. There's no evidence that.
May I interrupt? So, do you dispute what the judge said when he said CAI and Sotheby have accounted not only for the actual dollars that would have been paid out to Summers as an employee, but also the amount CAI would have spent on Summers' behalf for Social Security, health, and dental insurance, vacation pay, as well as tax savings to Summers based on pre-tax contributions he would have been able to make as an employee?
It's my understanding that the trial court's position that you just read, that referred to using the figures of other individuals that the employer properly classified and treated as employees. They did the calculation, the analysis on that other person's wage rate, and that's not permitted under Massachusetts law. We can't come back in, especially in the private sector, we can't come back in and guess the employer's subjective reasons for paying one person a different hourly wage than another.
You don't even have to get to that. You can simply say, yes, that was the employer, the hirer of the putative independent contractor, but nobody heard from the individual to contest that.
That's true, Your Honor.
But it still could be decided on summary judgment. What if the individual doesn't contest? Yeah, those were the terms of my contract. Then the judge presumably could decide it on summary judgment, damages.
But that isn't what happened here. His case was thrown out before he had an opportunity to present his damages.
Could I just ask one question? The hourly rate comes to $65 an hour, right, on this record? Now, would you say that, forget summary judgment, whatever, but you now are before the fact finder, $65 is what is calculated he gets paid for an hour. So then, if the employer could show, using the $65 an hour, that, that becomes the base. So then you figure out what would be the 401k contribution, what would be the overtime, what would be the health may be just the same for everybody, but there are certain things to which that 65 is very critical.
And it's unique to each individual, and that's really what I'm getting at under that Section 148B, the misclassification statute. The damages need to be determined on a case-by-case basis. What if this employee had a horrible injury and needed surgery and incurred $10,000 in medical expenses?
Yeah, those are
But that would be a different scenario. I think it has to be decided on a case-by-case basis, unique to that individual, not based on comparisons with wages paid to other workers. You know, employers typically pay employees at varying rates for doing the same or similar work for a wide variety of reasons. Maybe an individual who's not particularly well qualified gets paid a higher rate than his coworker because they have great contacts in the industry, and the employer is willing to pay a premium for that. That's that person's wage rate.
Thank you, Ms. Saba.
Thank you.
Good morning, Mr. O'Hala.
Good morning. May it please the Court. This case presents an opportunity for the Court to speak to an express term contained in statutory language of the credit that Chapter 149, Section 50 expressly provides.
Well, why isn't this exactly the problem that's been referenced by counsel? Why should the employer be given an opportunity to sort of reframe the compensation after the fact?
We would respectfully disagree with the characterization that it is reframing it, and we would actually use an objective approach to this. I think we're not asking the Court to get inside what was in the employer's head. We're looking at
Don't you have an affidavit, though, that's somebody, some HR person said, well, Mr. Summers wasn't as qualified as somebody else, so actually his wage rate would have been, pick a number.
We do, and that's in an affidavit.
Is that objective?
I believe that I do believe it is, if you're especially looking at the qualifications of the employer and the base compensation. There are determinations that can clearly be made. And when you look at the wage that was paid to, the hourly wage that was paid to Mr. Summers, it clearly exceeded both of the people that got the job that Mr. Summers was interested in.
Mr. O'Hala, assuming that that is the case, I mean, you know, when you're operating a statutory scheme like this, and I think you're correct, it really is not, you know, the business of a court to figure out whether you were doing it deliberately or not deliberately. I mean, it just wasn't.
We're not suggesting that that intent is what the Court's supposed to be looking at. We're simply saying that this particular appellant, Mr. Summers, has no damages, that he was paid substantially more than...
He was paid what he was paid for whatever reasons.
As an independent contractor.
No. He's
by contract.
He's not an independent contractor because that has been established because your client violated. I don't care whether he did it deliberately or it did it deliberately or not. It's just violated. It might be, for example, take a situation where, you know, somebody with his expertise is needed only for a particular project that your client has at the time. Right? And this person says, well, I'm not going to come on board, you know, to work for, what was the comparable, $8 an hour or whatever, what was the comparable to what was the claim that your client said he should have been paid as an employee, would have been paid as an employee?
He would have been paid at the rate.
Yeah, I know. What was that rate?
$90,000 a year.
$90,000
a year.
Right.
Whatever. I was trying to think if it was an hourly rate.
No, it was an annual compensation of $90,000 as an exempt employee, by the way, Your Honor. And so there's a number of levels of things going on here. They talk.
So he has the need of this expertise for this one project because your client happens to be in the business of doing all kinds of projects for other companies, right? And so he says, I mean, there's a very simple solution. I can only hire you for 5 months, and so I have an employment agreement that says the agreement is for 5 months. You're an employee for 5 months. It's not as if the employer is left without a remedy here.
No, but I would respectfully suggest that that the example, Chief Justice, you're using is not applicable to the facts of this record in this respect.
No, I understand that, because your client decided that it didn't want to have somebody, at least it says, permanently, maybe because this person wasn't qualified, but right then it had a need. My concern is, are we setting, either, whichever way we go, are we setting up either a system, which, according to the Attorney General, would make the entire scope of statutes unworkable, and if we go with the Attorney General, leaving an employer without any remedies if it wants to have short-term employment contracts, and you can have short-term employment contracts.
I think the tension here, Your Honor, on a policy level is the difference between what the appellant is saying is that the rate is the rate, and you don't get to change the rate. You don't even get to say what the rate is comprised of, although I hear the Attorney General saying you couldn't do that at trial, versus the policy considerations that are embedded in Swift versus AutoZone and in the FLSA cases where they say windfall recoveries are not permissible. You are entitled to credit, and the plaintiff should not be put into a position where they get a double recovery. And in substance, what we're saying is that's exactly what they get here by being paid all of those things and more by the hourly rate provided to the independent
But how am I to determine that? For example, if somebody who agrees to be employed for 5 months may be in a position to negotiate a much higher wage than somebody who is being employed for a year, not because of overhead or other kinds of reasons like that, but because for 5 months, at the end of 5 months, I may not be able to find any other employment. And will say, I will accept an employment, but I have to get paid more than your year-round.
I
right?
would say that's possible, Your Honor, but it's not this case. It simply isn't.
Well, I mean, you say it isn't.
But on the basis of the record evidence presented before the court where Mr. Summers acknowledged that the benefits that were he to be an employee, which is what this court looked at in the affidavit, he did not contest that those figures added into the highest level person who was an employee at that position on the record, Mr. McNamara, still amounted to an amount less than, and therefore he suffered no damages. And that's what the court ultimately decided. By taking a different position, Your Honor, and applying 65 as the baseline, I think, and saying that there is no crediting analysis to be performed, I think is a mistake, and I think it's contrary to the express statutory language.
Which is the language in 150?
It's 150, and it provides that that no defense for failure to pay other than, and this operative language is a valid set-off of the same.
But a set-off, I mean, I think it's the Attorney General that it might be. I mean, a set-off could very well mean there's an obligation owed by the employee to the employer that gets to get set off. Set-off doesn't mean if we do a little calculation, you'd actually get paid less than you would have.
Respectfully, I disagree. I would agree the former clearly counts, and there's decisions to that effect, and the Attorney General concedes as much. What we would point to as illustrative are the federal labor, the FLSA cases, where that precise crediting is in fact done on comp time, where you're trading off one thing for another. Here, in this instance, the rates that were paid to this independent contractor were so far above the rates of any employee that in substance the employer had paid those, and it would be a windfall.
Which were the employees that had worked for a limited period of time?
Well, certainly both Mr. Bispham, and Mr. McNamara. Mr. Bispham was hired in July of 2004, I believe.
No, but he was still employed, correct?
Yes. He was.
Yes, so we don't know how long he was going to work for.
Mr. McNamara was subsequent to. He was February of 2006. So you have
No, not for how long have you been employed, but they hadn't been employed for short periods of time. They had been employed shortly before and were continuing to be employed. So they're long-term employees.
That's true. Although
are they still employed?
It's outside the record, but they are. Your
Yes,
Honor.
so they're long-term employees.
Not at the time of the decision that was made
No,
by
but
this court.
there's a difference between a long-term employee and a short-term employee. And you're saying a short-term employee's got no. I mean, I understand your argument. It's a good argument to make to a jury.
I think as a matter of law, the court was correct in looking at, are there any provable damages, taking into account the concession made by Mr. Summers.
Let me ask you this, if I could.
Sure.
Let's assume that instead of Mr. Summers bringing this himself, and I don't remember, the Attorney General can enforce this statute, right?
I believe that's correct.
Could do so on behalf of Mr. Summers, correct?
Yes.
The Attorney General, I mean, beyond Mr. Summers and his wages, there are policy considerations, because when you classify somebody or misclassify somebody as an independent contractor, you're not paying workers' comp, you're not paying employment. There's a lot of tax things you're not paying. It's beneficial to you to classify as an independent contractor, correct?
I would respectfully suggest that they were paying above the rate that they should have paid were he an employee, and that's precisely the argument that would rebut that.
Not to the Commonwealth.
Not to the Commonwealth. So I'm saying there are...
They were not paying
I'm
workers'
sorry,
comp,
I
so
understand.
now this is the Attorney General, and the state has received
Nada.
none. Right?
True.
So the state brings this case on behalf of Mr. Summers, and maybe others. What would they be entitled to recover?
Well, respectfully, I don't.
I mean, I don't know that. I really don't know. Do they get damages, or is it just injunctive relief, or what is it?
I think the statute under the Wage Act says injunctive relief or damages. I believe it permits both, and it's the Wage Act is a treble damages and attorney's fees statute. It's a very heavy club, which is precisely why this is a bad case for application of this credit the wrong way, because there are significant consequences. To follow out, it makes the argument that Mr. Lichten is making is it will encourage employees to be paid less. That's precisely the opposite of what happened with Mr. Summers here. He was paid substantially more as part of his overhead, and what we're saying is that this is a total.
That's your
Right.
position.
Right.
It's not a legally mandated position.
All we're saying is that the trial court correctly applied the set-off statute.
As a matter of law.
That as a matter of law, that the court was permitted to apply the set-off precisely as the express terms provide.
Doesn't that invite, though, the employer to classify as many people, even though they understand it's misclassification, but to misclassify as many people as they can, because they can always do this after the fact set-off. They don't have to pay workers' comp. They don't have to pay unemployment insurance. It's a great benefit to them.
I think it takes great risk with treble damages and attorney's fees. Risk
Let me ask you this, Mr. O'Hara. 150 starts with the Attorney General may make complaint.
Correct.
So, in your scenario, there's been a violation of the statute. Has your client filed all of the taxes that it would have had to pay?
We assumed for sake of argument.
No, it's a factual question.
Oh, outside of the record, Your Honor. I think, have they paid?
I mean, should the court be saying, okay, Mr. Summers, you only get this, but I'm ordering the employer to pay these taxes?
Could the Attorney General come in and argue that?
No. I'm just, the court is now saying, we've discussed, there's several benefits. Various people get various benefits, one of which is the Commonwealth gets to have all of the employers pay into various pots of money that can be used in a distributive way. So now what you do is you do the set-off, but you haven't paid the taxes.
We would suggest, Your Honor, no, because the rate that was paid to Mr. Summers, substantially above to the independent, while he was an independent contractor vis-a-vis the employer, encompassed such a large amount that it would encompass self-employer tax, vacation, and all of those, what Justice Cordy calls overhead, would be embodied in that, so that the Commonwealth.
No, but now he's not getting that benefit.
That Mr. Summers is, he is getting that. He was getting that benefit. He did get that benefit in the $65 an hour rate. That's
yes,
what,
but the Commonwealth has received nothing.
The Commonwealth would receive the independent contractors' employment. What would be missing, I believe, Your Honor, from the misclassification may be Social Security if he was not a 1099 and did it on his own, which he was, and Justice Cordy pointed out correctly, for 10 years he served as an independent contractor going from job to job to job. I have very brief time left, Your Honor.
I'd like to ask go ahead. Well, I'd like to ask another question. There is an age discrimination claim
There is.
here also. Why is it not a jury question about whether the person or people hired had greater or lesser qualifications than Mr. Summers?
Mr. Summers had no voice-centric
Mr.
IP.
McNamara didn't either at one point.
Mr. McNamara did have it coming in voice-centric from 3Com, and it was established as a matter of record, and Mr. Summers did not dispute that he had that experience and that Mr. Summers did not. It was an undisputed fact in that case, and that precisely is so as a matter of summary judgment, it was simply undisputed.
So simply because of that one qualification, that's what makes it undisputed?
That was the position, the product, CAP, was a voice-over Internet protocol
Even though your
product.
company earlier had said that Mr. McNamara wasn't sufficiently qualified. I think I've got the right name.
No, I don't think that's what happened. What happened was, for budgetary reasons, he was not hired at that time. They interviewed 19 people, and the position was put on hold for budgetary reasons. And then in February of 2006, Mr. McNamara was subsequently hired. There was no dispute that Mr. McNamara had greater experience with regard to the VoIP protocol, and Mr. Summers acknowledged as much, that his sum and substance was simply in a month that he tinkered on his own. So I don't think there's any dispute on that record. And one last thing, Your Honor.
No, before you don't have that, but Justice Gans has it.
That's okay.
I mean, I apologize. I thought Justice Gans had a question, but that's fine. Thank you, Mr. O'Hara.
Thank you.
Let's go.
SJC